morning, 27th April 2020. This is Suraj Singh, International Professional Engineer, Chartered Engineer India, Project Management, Quality Management, a routine talk being disseminated to you according to civil engineering requirement and according to whatever requirement. This talk is very much important for all those engineers who are probably not aware about what is act, what is management, what is quality and all that. I thought this to continue and disseminate this information amongst our engineers, because engineers are not very well aware of what should be done. I have already talked to you about Contract Act, which is applicable in our country, Bharat, India. This is Indian Contract Act 1872, which is which was enacted during British regime. There were many amendments after that. What was said, I explained the preambles. It's expedient to define and amend certain parts of law relating to contracts, and this is where contract was enacted, Contract Act, and this present short title is, this may be called Indian Contract Act, and I have gone through various articles of this, interpretation clause, etc. And this was later, I talked to you many clauses, and what is promise, and what is, you can say, proposal, what is proposal, what is promise, reciprocal promise, what is agreement, what is contract, and all that. And it was said in chapter 1, it was communication, acceptance and revocation of proposal. What is communication, what is acceptance, what is revocation of proposal, and also then you can say there was later on Article 5, which is revocation of proposals and acceptance, and there how it is made, what is proposal, and revocation how made, if proposal is revealed, and acceptance how it is, must be absolute and qualified, then acceptance of performing conditions, and promise, express and implied, what is promise, and then it was contract, voidable contract, void agreements. Then if you go further, we find article section 11, competent to contract, who is competent to contract, and then article section 12, let's say section 12, what sound mind for purpose of contracting, then what is sound mind, and then you go further, it was that section 13, consent, what is consent, and what is free consent, coercion, what is undue influence, what is fraud, what is misrepresentation, mistake, then coercion defined, and then 24 says, 16 says undue influence, what is that. After that, if you go further, you will find what is fraud, and after that I discuss about, according to say, misrepresentation explained, and voidability of agreement. This is 19, section 19, and then 19A, power to set aside contract, and later on you see agreement void, section 20, agreement void, and after later on 21, which is effect of mistake as to law, and 22 is contract caused by mistake. 23 is what consideration and objects are lawful and what are not lawful. Then it was later followed by this is 24, section 24, this is agreement void. 25 is agreement without consideration void, and 24, this is 25, and if you see later on It was about, I'm just scanning, 26 agreement in restraint of marriage void, and 27 is agreement in restraint of trade void, 28 is agreement restraint to legal proceedings void, and then 31, no, this is 29, this is agreement void for uncertainty, agreement void for uncertainty, and later after that agreement by way of wager void, and wager void, chapter 3, that is contingent contracts. Contingent contract defined, what is contingent contract, enforcement of contracts, enforcement, and then 33 enforcement of contracts contingent, and 34 what agent when when event on which contract is contingent, 33, and 35 is when contract becomes void, 35 when contract is void, which are contingent. Agreement contingent on impossible venue events, 36. And chapter 4 is this performance of contract, obligation of parties to contract, and effect of refusal to accept offer of performance, effect of refusal of party to perform promise wholly, and by whom contracts must be performed, section 40, person by whom promise is to be performed, effect of accepting performance from third person, devolution of joint liabilities, 42, 43 is any one of joint promises may be compelled to perform, and then sharing of loss by default in contribution, and effect of release of one joint promisor, devolution of joint rights, is 45, time and place for performance, 46, 47 is time and place for performance of promise, and 48 is application for performance on certain day, 49 place for performance of promise, and performance in manner or at time prescribed, and 51 promise not bound to perform unless reciprocal promise ready and willing to perform, order of performance of reciprocal promises, liability of party preventing event on which contract is to take effect, and this is effect of section 50, effect of default as to that promise which should be first performed, and 55 effect of failure to perform at fixed time. Promisee is entitled to compensation from promisor. 56 agreement to do impossible act, and 57 is reciprocal promise to do things legal. 58 is alternative promise, one branch being illegal. 59 application of payment where debt to be discharged is indicated. Application of payment where neither party appropriates, and contingent which need not be performed was 62. 63 promise is number only in this section. 63 promise may dispense with or remit performance of promise. 64 is consequences of rescission or voidable contract, and 65 is obligation of person who has received advantage under void agreement. 66 mode of communication or revoking decision. 67 is effect of neglect of promise to afford promisor. 60 in chapter 5 certain relations resembling those created by contract. 68 claims for necessaries supplied to person incapable of contracting. And claims for necessaries supplied to person incapable of contracting. Later is for 69, reimbursement of persons paying money due by another. Reimbursement of person paying money due by another. 70, obligation of person enjoying benefit of non-gratuitous act. 71, responsibility of finder of goods. 72 is liability of person to whom money is paid or thing delivered. 70, so then this chapter 6 of consequences of breach of contract. 73, compensation for loss of damage caused by breach of contract. 73, this is, and it is 74, compensation for breach of contract. 124, contract of indemnity. 125, rights to indemnity holder. 126, contract of guarantee. 127, consideration for guarantee. 128, short is liability. And 129, continuing guarantee. 130, revocation of continuing guarantee. 131, revocation of continuing guarantee by short is death. 132, liability of two persons, primarily liable, not affected. Okay. Then 133, discharge of surety by variance in terms of contract. Followed by 134, discharge of surety by release of discharge. 135, discharge of surety when creditor compounds with. And then it is 137, creditor's forbearance to sue does not discharge surety. 138, release of one co-surety does not discharge other. 139, discharge of surety by Creditors Act. And 140, rights of surety on payment of performance. 141, surety's right to benefit of creditor's securities. 142, guarantee obtained by misrepresentation invalid. And 143 is guarantee obtained by concealment invalid. 143, guarantee obtained by concealment invalid. And 144, guarantee on contract that creditor shall not act on it until co-surety joins. 145, implied promise to indemnify surety. And 146, co-surety is liable to contribute equally. 147 is liability of co-sureties bound in different sums. Then chapter 9, bailment. 148, bailment, bailer and bailee. 149, delivery to bailee housemaid. 150, bailer's duty to disclose faults. And 151, care to be taken by bailee. 152, bailee when not liable for loss. Termination of bailment by bailee. 153, termination of bailment by Bailies Act. 54, liability of bailee making unauthorized use of goods. And 155, effect of mixture with bailer's consent of his goods with bailees. 156, effect of mixture without bailer's consent. 157, effect of mixture without bailer's consent. 158, to repayment of bailer of necessary expenses. Repayment is 158. 159, restoration of goods lent gratuitously. 160, return of goods bailed on expiration of time. 161 bailey's responsibility when goods are not duly returned. 162 termination of gratuitous bailment by death. Bailer entitled to increase or profit from goods bailed. One 63 bailer entitled to increase or profit from goods bailed, and 164 is 163. 160 bailer's responsibility to bailee. After that, 165 bailment by several joint owners. 166 bailee not responsible on redelivery, and 167 right of third person claiming goods bailed. I'm just telling you all these points first. 168 right of finder of goods. 169 when finder of thing commonly on sale by may sell it is 169. 170 is bailee's particular line, and 171 general line of bankers, factors, wharfingers, attorneys and policy brokers. Then bailment of pledges. 172 pledge, pawner and pawnee. 173 pawnee's right of retainer. 173 pawnee's right of retainer. 174 pawnee not to retain for debt or promise. 175 pawnee's right as to extraordinary expenses. 176 is pawnee's right where pawner makes default. 177 defaulting pawner's right to redeem. 178 pledge by mercantile agent. 178 a pledge by person. Well, that's something else one. Then 179 pledge where pawner has only a limited interest. 180, this is sued by bailer or bailee against wrongdoers. 180 is sued by bailer or bailee against wrongdoers. 181 apportionment of relief or compensation obtained by such suits. 180 is chapter 10 agency, appointment and authority of agents. Agency is chapter 10, appointment of authority of agent. 182 agent and principal defined. 183 who may employ agent. 184 who may be an agent. 185 consideration not necessary. 186 agent's authority may be expressed or implied. 183, 186, 187 definition of express and implied authority. 188 extent of agent's authority. 188 extent of agent's authority. 189 agent's authority in an emergency. Then when agent cannot delegate. 190. 191 sub-agent defined. 192 representation of principal by sub-agent properly appointed. 193 agent's responsibility for sub-agent appointed without authority. 194 relation between principal and person duly appointed by agent to act in business or of agency. 195 agent's duty in naming such a person. Then 196 ratification is right of person as to act done for him without his authority. 197 rectification may be expressed or implied. 198 knowledge requisite for valid ratification. 198 this is. 199 effect of ratifying an unauthorized act forming part of a transaction. 199 effects of ratifying unauthorized act. 200 ratification of unauthorized act cannot injure third person. Then it is revocation of authority. 201 termination of agency. 202 termination of agency where agent has an interest in subject matter. And 203 when principal may revoke agent's authority. 204 revocation where authority has been partly exercised. 205 compensation for revocation of principal or renunciation by agent. 206 notice of revocation or renunciation. 206. Then 207 revocation and renunciation may be expressed, and then 208 when termination of agent's authority takes effect. This is 209 agent's duty on termination of agency. 210 termination of sub-agent's authority. Now agent's duty to principal. 211 agent's duty in conducting principal's business. 212 skill and diligence required from agent. 213 agent's accounts. 214 agent's duty to communicate with principal. 215 right of principal when agent deals on his own account. And 216 principal's right to benefit gained by agent. 217 agent's right or retainer out of sums received on principal's account. 218 agent's duty to pay sums received for principal. 219 when agent's remuneration becomes due. 220 agent not entitled to remuneration for business misconducted. And this was 220. Okay, now 221 agent's line on principal's property. 222 agent to be indemnified against consequences of lawful act. 223 agent to be indemnified against consequences of acts done in good faith. 224 non-liability of employer of agent to do a criminal act. 225 compensation to agent for injury caused by principal's neglect. 226 enforcement and consequences of agent's contracts. And 227 principal how far bound when agent exceeds authority. 228 principal not bound when excess of agent's authority is not separable. 229 consequences of notice given to agent. 230 agent cannot personally enforce nor be bound by contracts on behalf of principal. 231 rights of parties to a contract made by agent not disclosed. 232 performance of contract with agent supposed to be principal. 233 right of person dealing with agent personally liable. 234 consequences of inducing agent or principal to act on behalf of principal or agent. 235 liability of pretended agent. 236 person falsely contracting as agent not entitled to perform. 237 liability of principal inducing belief that agents authorized acts or authorized. And 238 effect on agreement of misrepresentation of fraud by agent. And then that's all. And now, as I said, I explained to you up to many pages, up to Bailey. I think I was on Bailey and Baylor chapter. This was a yawning. I should move fast. I think it's not. Bailey. So I'm just scanning back. I explained to you about contract. What is contract? What is contract act? and what is necessity, what is urgency, what is basic requirement to know about what is contract act, because every day you enter into many contracts which you are not clear about, you are unaware about, because we should be sorry, unaware, you should be aware of that, because if you are not aware of that, you can be beaten anyway. You can be beaten by people, by those parties who enjoy your benefit, your acts. So I was here now. I was here on, I think, which article 1656, effect of mixture without bailor's consent when goods can be separated, also done. And I think effect of mixture without bailor's consent when goods cannot be separated, this was done. Was repayment by bailor of necessary expenses. Well, I think I was somewhere else. Okay, I'll start here, no problem. Let us say 157 or number 6. Let us say 156. Okay, we start 155 just because it's already done. So no problem. We'll start that as well. I don't think any problem is this one. And let me find also here if I can find something done. So let me say, let me also find this. This act is also there. So I'm first trying so that I can show you applications, files, and I think it is in phone, I'm sure. So I can open here also for showing to you, and that's better. 155 I am at, so I'll go to 155 straight away. Let me show you first what I'm going to show you better here. Well, let me show you first what is intended here. Intended here is this is Indian Contract Act 1872. Just for information I am showing, because I am talking about this. I have reached up to 155 sections. Just for information, yesterday all were not available. But if you see yesterday's video, you will find all these sections discussed. And I was on article 5155. Take some time because this was regarding bailee and bailor. I have talked all what is contract, what is promise, what is promisor, and what is performance of contract, who is who. All those terms were decided, were agreed, were discussed according to Act. It was what Act says, and when we understand Contract Act, we feel more responsible, because after all, agency, etc., it says, I'm sorry. It's my mistake. It's that one. That's the one. It's that one. Yes, inner contractor. Actually, it's that one. Let me see. I actually opened wrong file. This is that, This is Indian contract, real one, which I am showing from text. It may not be a little clear to you, but this is what I am showing to you. Let me go to that one. Indian Contract Act means you conduct everyday many acts, you enter any acts. Example, you go somewhere, you travel, you buy some ticket, travel ticket, that's also a contract. You take flight, that's also a contract. You buy something, that's also a contract. And you take some service, that's also a contract. Even if it's not signed, it's agreed upon, it's understood that you are paying something for service, you're getting a service, it's a contract. You are using some employee, labor, worker, etc. for your job, you are paying them, that's a contract. It's not necessary, everything should be written. Contract is contract, there's agreement, there are two parties, both parties agree for something. You are one party, other one, you are in fact an employer, other party is a person who is employed. So both are there for whatever transaction, for whatever condition, for whatever fees are to be paid or payment to be made. So it's a contract, and that's more important to understand rather than writing for every day. You cannot write something if you are using some person for 1 day or 2 day. It's not necessary to write something. Trust is also there, and that's actually a contract. You may not even realize that contract is contract. Now I am going to article 155, which is near here, which we discussed yesterday, but I want to again overlap that discussion so that something should be clear. Article 155, come on, want to say 46. 146 and then there's 147. Why is taking too long? 1, and it is now 155. It has come 155 here. This is 155. Effect of mixture with bailers. 155 effects of mixture. Now what it says, if you read 155 says effect of mixture with bailers consent of his goods with bailies. If bailey with consent of bailer mixes goods of bailer with his own goods, bailer and bailey shall have an interest in proportion to their respective shares. Mixture and in mixture thus produced. 156, section 156, effect of mixture without bailer's consent when goods can be separated. 156, let me show you 156 first. 156 is this one. This is 156. Effect of mixture with effect of mixture without okay, this is the effect of mixture. Probably so what I say, this is 156. Effect of mixture without bailer's consent when goods can be separated. When goods can be separated, if bailey without consent of bailer mixes the goods of bailer with his own goods and goods can be separated or divided Property in goods remains in parties respectively, but Bailey is bound to bear expense of separation or division and any damage arising from mixture. So that is 156. Now 157, effects of mixture without baler's consent. 157, effect of mixture without baler consent. Wait a minute. Effects of mixture maybe you can see I don't know again. Effects of mixture without baler's consent. Effects of mixture without baler's consent. It says effects of mixture without baler consent when goods cannot be separated. If Bailey without consent of baler mixes goods of baler with his own goods in such a manner that it is impossible to separate goods baled from other goods and deliver them back, baler is entitled to be compensated by Bailey for loss of goods. And I go to 158, repayment. 158 is repayment. Repayment by baler is 158. My God, that's the problem here. No. 158. The repayment by baler. 158. Repayment by baler. Condition of baler. I'm just going to part of this because I cannot blow it and I cannot show you smaller font, so you can read yourself by downloading that. You can download that, no problem at all. It's available. So 158, repayment by baler of necessary expenses, whereby a condition of bailment. By condition of bailment, goods are to be kept or to be carried or to have work done upon them by baler for baler, and Bailey is to receive no remuneration. Baler shall repay to Bailey necessary expenses incurred by him for purpose of bailment. Let me repeat: repayment by baler of necessary expenses, where by condition of bailment goods are to be kept or to be carried or to have work done upon them by Bailey for baler, and Bailey is to receive no remuneration, or baler shall repay to Bailey necessary expenses incurred by him for purpose of bailment. Now 159, restoration of goods lent gratuitously. 159, restoration of goods restoration of goods. What can you do? Now, restoration of goods lent gratuitously. Lender of a thing for use may at any time require its return if loan was gratuitous, even though he lent it for a specified time or purpose, but if on faith of such loan made for a specified time or purpose, borrower has acted in such a manner that return of thing lent before time agreed upon would cause him loss exceeding benefit actually derived by him from loan. Lender must, if he compels return, indemnify borrower for amount on which loss would occasion exceeds benefits so derived. Return. Okay, now let me read it again. It's little, no, not very clear. Restoration of goods lent. Restoration of goods lent gratuitously. Lender of a thing for use may at any time require its return if loan was gratuitous, even though he lent it for a specified time or purpose. But if, on faith of such loan made for a specified time or purpose, borrower has acted in such a manner that return of a thing lent before time agreed upon would cause him loss exceeding benefit actually derived by him from loan. Lender must, return, if he compels return, indemnify borrower for amount in which, wait a minute, water bottle has fallen. Wait a minute, please, wait a minute. Just a minute. My God, it's difficult sometimes. Thermos fell actually, so it's okay. So what is that? I'm sorry. A lender must, if he compels return, indemnify borrower for amount in which loss so occasion exceeds benefit so derived. Let me repeat if misconception is there. Restoration of goods lent gratuitously. Lender of a thing, or is a thing, I don't think lies, lender of some item for use may at any time require its return if loan was gratuitous, even though he lent it for a specified time or purpose. But if, on faith of such loan made by a specified time or purpose, borrower has acted in such a manner that return of item lent before time agreed upon would cause him loss exceeding benefit actually derived by him from that loan. Lender must, if he compels return, indemnify borrower for amount in which loss or occasion exceeds benefits so derived. Now, section 160, return of goods billed on expiration. Return of goods billed. Return of goods billed on expiration purpose. Section 160, return of goods billed. That's once I say, you can see that yourself. It is 160, section 160 of this act. Section 160 says that return of goods billed on expiration. Return of goods billed on expiration of time or accomplishment of purpose. It's duty of bailee to return or deliver, according to bailor's directions, goods billed without demand as soon as time for which they were billed has expired, or purpose for which they were billed has been accomplished. After that, 161, bailee's responsibility when goods are not duly returned. Bailee's responsibility when goods are not duly returned. That's your fact. It's 161. 161 it says. No, actually, yeah, it's a so 161 says bail is responsibility when goods are not duly returned. If by default of bailee goods are not returned, delivered or tendered at proper time, he is responsible to bailer for whatever loss, if any, destruction or deterioration of goods from that time. 162. Termination of gratuitous bailment by death. 162. Termination of 162. Termination of gratuitous bailment and 163 also there. So 162. Termination of gratuitous bailment by death. A gratuitous bailment is terminated by death either of bailer or of bailee. 163. Bailer entitled to increase or profit from goods bailed. 163. Bailer entitled to increase or profit from goods bailed. This is 163. Bailer entitled to increase or what I will say. 163. Bailer entitled to increase or profit from goods bailed. Bailer entitled to increase or profit from goods bailed in absence of any contract to contrary. Bailer is bound to deliver to bailer. Bailee is bound to bailer or according to his directions. Any increase or profit which may have accrued from goods bailed. Bailer responsibility to bailee. This is 164. 164. Bailer's responsibility to bail. Purpose of this showing is just to tell you which one I am talking of. Details you can talk therein. 164. Bailer's responsibility to bailee. Bailer's responsibility to bailee. Bailer is responsible to bailee for any loss which bailee may sustain by reason that bailer was not entitled to make bailment or to receive back goods or to give directions respecting them. It says 164. Let me repeat it. Bailer's responsibility to bailee. Bailer is responsible to bailee for any loss which bailee may sustain by reason that bailer was not entitled to make bailment or to receive back goods or to give directions respecting them. Now 165. Bailment by several joint owners. Bailment by several joint owners, this 165. Bailments by several joint owners, and this is 165. So, bailment by several joint owners. If several joint owners of goods bail them, bailee may deliver them back to or according to directions of one joint owner without consent of all, in absence of any agreement to contrary. 166. Bailee not responsible on redelivery to bailer without title. 166. 166. Now, bailee not responsible on redelivery to bailer, bailee not responsible on redelivery to bailer without title. If bailer has no title to goods and bailee in good faith delivers them back to or according to of direction of bailer, bailee is not responsible to honor in respect of such delivery. 167. Right of third person claiming goods bailed. 167. 167. Right of third person claiming goods bailed. Right of third person claiming goods bailed. If a person other than bailer claims goods bailed, he may apply to court to stop delivery of goods to bailer and to decide title to goods. Next is 168. Right of finder of goods may sue for. 168. 168. Right of finders of goods. Right of finder of goods may sue for a specific reward offered. Right of finder of goods may sue for specific reward offered. Right of finder of goods may sue for specific reward offered. Finder of goods has no right. Finder of goods has no right to sue honor for compensation for trouble and expense voluntarily incurred by him to preserve goods and to find out honor. But he may retain goods against honor until he receives such compensation, and where honor has offered a specific reward for return of goods lost. Finder may sue for such reward and may retain goods until he receives it. This again Right of finder of goods may sue for specific rewards, etc. Finder of goods has no right. Finder of goods has no right to sue owner for compensation for trouble and expense voluntarily incurred by him to preserve goods and to find out owner. But he may retain goods against owner until he receives such compensation and where owner has offered a specific reward for return of goods lost. Finder may sue for such reward and may retain goods until he receives it. 169. When finder of thing commonly on sales may sell it. 169. Now 169. When finder of thing, finder of goods or thing, it says let's say two items. When finder of items commonly on sale may sell it. Finder of thing commonly on sale may sell it when a thing which is commonly subject of sale is lost, if owner cannot with reasonable diligence be found, or if he refuses upon demand to pay lawful charges of finder, finder may sell it. When thing is in danger, when thing is in danger of perishing or of losing greater part of its value, or when lawful charges of finder in respect of thing found amount to 2/3 of its value. This is a very important point. Let's say what again. 169. When finder of goods or thing commonly on sale may sell it when a thing which is commonly subject of sale is lost, if owner cannot with reasonable diligence be found, or if he refuses upon demand to pay lawful charges of finder, finder may sell it. When this good is in danger, thing is in danger of perishing or of losing greater part of its value, or when lawful charges of finder in respect of thing found amounts to 2/3 of value. So this is 169. Bailey's particular line. Bailey's particular line, this is 170. Bailey's particular line. Okay, Bailey's particular line. Where Bailey has, in accordance with purpose of bailment, rendered any service involving exercise of labor or skills in respect of goods bailed, he has, in absence of a contract to contrary, a right to retain such goods until then say he receives due remuneration for services he has rendered in respect of them. 170. Bailey's particular line. Where Bailey has, in accordance with purpose of bailment, rendered any service involving exercise of labor or skill in respect of right, in respect of goods, in respect of goods bailed, he has, in absence of contract to contrary, a right to retain such goods until he receives due remuneration for services he has rendered in respect of them. So, Bailey particular line is where Bailey has, in accordance with purpose of bailment, rendered service involving exercise of labor or skill in respect of goods bailed, has, in absence of a contract to contrary, a right to retain such goods until he receives due remuneration for services he has rendered in respect of them. Now, 171, general line of bankers, factors, war fingers, attorneys and policy brokers. 171. 171. 171. Let me guess some water. So I'm filling it in. It's of course not very hot yet. Some water is necessary for energy. So, general line of bankers, factors, war fingers, attorneys and policy brokers. Bankers, factors, war fingers, attorneys of a high court and policy brokers may, in absence of a contract to contrary, retain as a security for general balance of account retain as a security for a general balance of account any goods bailed to them, but no other person have a right to retain as a security for such balance goods bailed to them, unless there is an express contract to that effect. I repeat that. General line of bankers, factors, general line of bankers, factors, war fingers, attorneys and policy brokers. Bankers, factors, war fingers, attorneys of a high court and policy brokers may, in absence of a contract to contrary, retain as a security for general balance of accounts any goods billed to them, but no other persons have a right to retain as a security for such balance goods billed to them, unless there is an express contract into that effect. Pledge, this 172. Pledge, pawner and pawnee defined. 172. 172 pledge, pawner and pawnee defined. Pledge, pawner and pawnee. Bailment of goods as security for payment of a debt or performance of a promise is called pledge. Bailment of goods as security for payment or payment of a debt or performance of a promise is called pledge. Bailer is in this cause, bailer is in this case called pawner. Bailer is in this case called pawner, P-A-W-N-O-R. Bailee is called pawnee, pawner and pawnee. Alright, this means bailer in this case called pawner, bailee is called pawnee, and this is bailment of goods as security for payment of a debt or performance of promise is called pledge. Bailer is in this case called pawner, bailee is called pawnee. 173 pawnee's right of retainer. 173 is pawnee's right to pawner's right of retainer. Pawner's right of retainer. Pawnee's right of retainer. Pawnee may retain goods pledged not only for payment of debt or performance of promise, but for interest of debt and all necessary expenses incurred by him in respect of possession or for preservation of goods pledged. So this pawnee may retain goods pledged not only for payment of debt or performance of promise, but for interest of debt and all necessary expenses incurred by it in respect of possession or for preservation of goods pledged. 174 pawnee not to retain. 174, this is pawnee not to retain for debt. Pawnee not to retain for debt or promise other than that for which goods pledged. Presumption in case of subsequent advances. Pawnee shall not, in absence of a contract to that effect, retain goods pledged for any debt or promise other than debt or promise for which they are pledged. But such contract, in absence of anything to contrary, shall be presumed in regard to subsequent advances made by pawnee. 175 pawnee's right as to extraordinary expenses incurred. 175 Pawnee's right as to extraordinary expenses incurred. Pawnee is entitled to receive from pawner extraordinary expenses incurred by it for preservation of goods pledged. 176. Pawnee's right where pawner makes default. Pawnee's right where pawner makes default. 176. Pawn is right where pawner makes default. Pawn is right where pawner makes default if pawner makes default in payment of debt or performance at stipulated time of promise in respect of which goods were pledged. Pawnee may bring a suit against pawner upon debt or promise and retain goods pledged as a collateral security, or he may sell goods pledged on giving pawner reasonable notice of sale. Let me repeat it. If pawner makes default in repayment of debt or performance at stipulated time of promise in respect of which goods were pledged, pawnee may bring a suit against pawner upon debt or promise and retain goods pledged as collateral security, or he may sell thing pledged on giving pawner reasonable notice of sale. If proceeds of such sale are less than amount due in respect of debt or promise, pawner is still liable to pay balance. If proceeds of sale are greater than amount so due, pawnee shall pay over surplus to pawner. Now 177. Defaulting pawner's right to redeem. This is 177. Defaulting pawner's right to redeem. Defaulting pawner's right to redeem. Defaulting pawner's right to redeem. If a time is stipulated for payment of debt, if a time is stipulated for a payment of debt or performance of promise for which pledge is made, and pawner makes default in payment of debt or performance of promise at stipulated time, he may redeem goods placed at any subsequent time before actual sale of them, but he must in that case pay in addition any expenses which have arisen from his default. So let me repeat it. If a time is stipulated for repayment of debt, if a time is stipulated for payment of a debt or performance of promise for which pledge is made, and pawner makes default in payment of debt or performance of promise at stipulated time, it may redeem goods He may redeem goods placed at any subsequent time before actual sale of them, but he must in that case pay in addition any expenses which have arisen from his default. Pledge by mercantile agent. Pledge by mercantile agent 178. Pledge by mercantile agent. Pledge by mercantile agent. Pledge by mercantile agent, where a mercantile agent is with consent of owner. Where a mercantile agent is with consent of owner in possession of goods or document of titles to goods, any pledge made by him when acting in ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by owner of goods to make same, provided that pawnee acts in good faith and has not at time of pledge notice that owner has no authority to place, is no authority to place. Let it, pledge by mercantile agent, where a mercantile agent is with consent of owner, where a mercantile agent is with consent of owner in possession of goods or documents of title to goods, any pledge made by him when acting in ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by owner of goods to make same, provided that pawnee acts in good faith and has not at time or time of pledge notice that pawner has no authority to pledge. Explanation is, in this case, in this section, expression mercantile agent and documents of title shall have meaning assigned to them in Indian Sales of Goods Act 1930. 178A 178A 178A. Pledge by person in possession. Pledge by person in possession under voidable contract. When pawner has obtained possession of goods, pledged by his under a contract voidable under section 19 or section 19A, but contract has not been rescinded at time of pledge, pawnee acquires a good title to goods provided he acts in good faith and without notice of pawner's defect of title. Let me say again, pledge 178A, pledge by person in possession under voidable contract. When pawner has obtained possession of goods pledged by him under a contract voidable under section 19 of section 19A, but contract has not been rescinded at time of pledge. Pawnee acquires a good title to goods, provided he acts in good faith and without notice of pawner's defect of title. Pledge where pawner has only a limited interest. 179, 179, 179. Pledge where pawner has only a limited interest, where a person pledges goods in which he has only a limited interest. Pledge is valid to extent of that interest. Suits by bailies or bailiff against wrongdoers. Now 180. Suit by bailiff or bailey against wrongdoers. Article section 180. Suit by bailiff or bailey against wrongdoer. 180. Suit by bailiff or bailey against wrongdoer. If a third person wrongfully deprives bailey, if a third person wrongfully deprives bailey of use of possession of goods bailed or does them any injury, bailey is entitled to use such remedies as owner might have used in like case, if no bailment had been made, and either bailiff or bailey may bring a suit against a third person for such deprivation or injury. Since if a third person wrongfully deprives bailey of use of possession of goods bailed or does them any injury, bailey is entitled to use such remedies as owner might have used in like case, if no bailment had been made, and either bailiff or bailey may bring a suit against third person for such deprivation or injury. Now 181. Apportionment of relief or compensation obtained by such suits. 181. Apportionment of relief or compensation obtained by such suits. Whatever is obtained by way of relief or compensation in any such suit shall, as between bailiff and bailey, be dealt with according to their respective interests. Chapter 10. Now we are going to talk about agency. Appointment and authority of agents. This is Agency Chapter 10 and it is Section 182. Agency. Agency. Agent and principal defined. An agent is a person employed to do certain act for another or to represent another in dealings with third person. Person for whom such act is done or who is so represented is called principal. So again, agent is a person employed to do certain or any act for another or to represent another in dealings with third persons. Person for whom such act is done or who is so represented is called principal. 183. Who may employ agent? 183. Who may employ agent? Who may employ agent? Person who is any person who is of age of majority according to law to which he is subject and who is of sound mind may employ an agent. 184. Who may be an agent? 184. Who may be an agent? As between principal and third person, between principal and third person, any person may become an agent, but no person who is not of age of majority and of sound mind can become an agent, so as to be responsible to his principal according to provisions in that behalf herein contained. As between principal and third person, any person may become an agent, but no person who is not of age of majority and of sound mind can become an agent, so as to be responsible to his principal according to provisions in that behalf herein contained. 185. Little yawning is better, you know. 185. Consideration not necessary. Consideration not necessary. No consideration is necessary to create an agency. 186. 186. Agent's authority may be expressed or implied. Agent's authority may be expressed or implied. Simple. It is 187. 187. Definition of expressed and implied authority. An authority is said to be expressed when it is given by words, is spoken or written. An authority is said to be implied when it is to be inferred from circumstances of case and things spoken or written or ordinary course of dealing may be accounted circumstances of case. Then 188 extent of agent's authority. Extent of agent's authority. Extent of agent's authority. An agent having an authority to do an act has authority to do every lawful act which is necessary in order to do such act. An agent having an authority to carry on a business has authority to do every lawful acts, things necessary for purpose, or usually done in course of conducting such business. 189 authority. 189 agent's authority in emergency. 189. 189. Agent's authority in an emergency. An agent has authority in an emergency to do all such acts for purpose of protecting his principal from loss as would be done by a person of ordinary prudence in his own case under similar circumstances. 190. 190. When agent cannot delegate, an agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken. To perform personally, unless by ordinary question of trade, a sub-agent may, or from nature of agency, a sub-agent must be employed. When agent cannot delegate, an agent cannot lawfully employ another one to perform acts which he has expressly or impliedly undertaken to perform personally, unless by ordinary custom of trade, a sub-agent may, or from nature of agency, okay, let me repeat it. An agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally, unless by ordinary custom of trade, a sub-agent may, or from nature of agency, a sub-agent is or from nature of agency, sub-agent must be employed. So it says, when agent cannot delegate, an agent cannot lawfully employ another one to perform acts which he has expressly or impliedly undertaken to perform personally, unless by ordinary custom of trade, a sub-agent may, or from nature of agency, a sub-agent must be employed. 191. Sub-agent defined. 191. Sub-agent defined. Sub-agent defined means sub-agent is a person employed by and acting under control of original agent in business of agency. Sub-agent is a person employed by and acting under control of original agent in business of agency. 192. Representation of principal by sub-agent properly appointed. I want to complete this Indian Contract Act because I'm also not able to walk for. Body is to be strained sometimes. Jam because of lockdown, cannot walk. 192. Representation of principal by sub-agent. representation of principal by sub-agent properly appointed. Representation of principal by sub-agent properly appointed. Where a sub-agent is properly appointed, sub-agent is properly appointed. Principal is so far as regards third person represented by sub-agent and is bound by and responsible for his acts as if he were an agent originally appointed by principal. So, where a sub-agent is properly appointed, principal is so far as regards third person represented by sub-agent and is bound by any responsible for his acts as if he were an agent originally appointed by principal. Agent's responsibility for sub-agent. Agent is responsible to principal for acts or sub-agents. Sub-agent's responsibility. Sub-agent is responsible for his acts to agent but not to principal, except in case of fraud or willful wrong. 193 says agent's responsibility for sub-agent. Agent's responsibility for sub-agent appointed without authority. When an agent without having authority to okay. 93 agent's responsibility. Sometimes 193 start. 193, this is section 193. Agent's responsibility for sub-agent appointed without authority. Where an agent without having authority, where an agent without having authority to do so has appointed a person to act as sub-agent, agent stands towards such person in relation of a principal to an agent and is responsible for acts both to principal and third person. Principal is not represented by or responsible for acts of a person so employed, nor is that person responsible to principal. Let me state, this is responsible statement is regarding agent's responsibility for sub-agent appointed without authority. It says where an agent without having authority to do so has appointed a person to act as sub-agent, agent stands towards such person in relation of a principal to an agent and is responsible for his acts both to principal and to third persons. Principal is not represented by or responsible for acts of person as implied, nor is that person responsible to principal. 194 194, and that is relation between principal and person duly appointed by agent to act in business or business of agency. One 94. No, I don't see the constitution. Also, okay, for permission. So I'm reading 194. Relation between principal and person duly appointed by agent to act in business of agency, where an agent holding an express or implied authority to name another person to act for principal in business of agency has named another person accordingly. Such person is not a sub-agent but an agent of principal for such part of business of agency as is entrusted to him. I read again. 194. Relation between principal and person duly appointed by agent to act in business or agency, where an agent holding an express or implied authority to name another person to act for principal in business of agency has named another person accordingly. Such person is not a subagent but an agent of principal for such part of business of agency as is entrusted to him. Now this agent and subagents I am explaining to you because these shall be required in your contracts with full authority and responsibility, and it's a very important part of this contract act which applies in profession of contractual engineering, contract engineering, and will find later on where these designations work. 195. Agent's duty in naming such person. Agent's duty in naming such person. 195 it is, and 195 is that. Now 195, let me see who are there first. I think maybe some people are there, not sure. Let's see. Good morning, Ms. Mola. Good morning, Ms. Mahendra Singh, and good morning, Ms. Chaudhary Raju. And who's there? Let's see who's there. So good morning here. Let's see. Right. We'll see. We'll continue on this. It's very important point. Is that 195. Now, agent's duty in naming such person, in selecting such agent for his principal, an agent is bound to exercise same amount of discretion as man of ordinary prudence would exercise in his own case, and if he does this, he is not responsible to principal for acts or negligence of agent so selected. I read it again. Agent's duty in naming such person, 195 section. Agent's duty is now in selecting such agent for his principal, an agent is bound to exercise same amount of discretion as a man of ordinary prudence would exercise in his own case, and if he does this, he is not responsible to principal for acts or negligence of agent so selected. Now, 190 ratification. Now, ratification it is, and another one. This is 996, 196. Ratification. No, actually, what ratification is an important point. We don't use this term ratification. Actually, it's verification. In fact, it's the word ratification is used. So 196 says right of person as to acts, right of person as to acts done for him without his authority, affects or ratification. Effect of ratification. Right of a person, right of person as to acts done for him without his authority. Effect of ratification, where acts are done by one person on behalf of another, where acts are done by one person on behalf of another but without his knowledge or authority. He may elect to ratify or to disown such act. Both. That person, he may elect to ratify or to disown such acts. If he ratifies them, same effects will follow as if they had been performed by his authority. 197. Ratification may be expressed or implied. 197. Ratification may be expressed or implied. Ratification may be expressed or may be implied in conduct of person on whose behalf acts are done. Now it's going further. 198. Knowledge requisite for valid ratification. 198. Wait a minute. Knowledge requisite for valid ratification. No valid ratification can be made by a person whose knowledge of facts of case is materially defective. No valid ratification can be made by a person whose knowledge of facts of case is materially defective. 199. Effect of ratifying authorized part of transaction. 29. Now, effect of ratifying or authorized act forming part of a transaction. A person ratifying any unauthorized act done on his behalf ratifies whole of transaction of which such act form part. 200. Ratification of unauthorized act cannot injure third person. Ratification of unauthorized act. 200. चला जाता है बार बार. Ratification of unauthorized act cannot injure third person. An act done by one person on behalf of another without such other person's authority, which if done with authority would have same effect of subjecting a third person to damage or of termination or of terminating any right or interest of a third person, cannot by ratification be made to have such effect. Revocation of authority now is 201. Termination of agency 201. Termination of agency. So, termination of agency. An agency is terminated by principal. An agency is terminated by principal revoking his authority or by agent renouncing business of agency or by business of agency being completed or by either principal or agent dying, principal or agent dying or becoming of unsound mind, or by principal being adjudicated and insolvent under provisions of any act for time being in force for relief of insolvent debtors. Repeat it. Termination of agency. An agency is terminated by principal revoking his authority or by agent renouncing business of agency or by business of agency or being completed or by either principal or agent dying or becoming of unsound mind or by principal being adjudicated insolvent under provision of any act for time being in force for relief of insolvent debt. So what says, how can you terminate it? Agency can be terminated by number one, principal itself revoking that authority of agent, or agent renounces business of agency. Number three, business of agency being completed, there is no more work, or by either principal or agent dying, both are dying, principal will die or agent will die, or becoming of unsound mind. Unsound mind is not suitable, mind is not, you can say, alert 1 and or by principal being adjudicated insolvent and court has declared the principal is insolvent 1, like that. So we go to 202, termination of agency where agent has an integral interest in subject matter. This is 202. Now, termination of agency where agent has an interest in subject matter. I think maybe it's too hoarse. Let me see which out of this. Okay, say where agent has himself an interest. Where agent has himself an interest in property which forms subject matter of agency, agent cannot, in absence of an express contract, be terminated to prejudice of such interest. Termination, where agent has himself an interest in property which forms subject matter of agency, agent cannot, in absence of an express contract, be terminated to prejudice of such interest. Is a law. Then 203, when principal may revoke agent's authority. 203. Principal may save as is otherwise provided by last proceedings preceding section, revoke authority given to his agent any time before authority has been exercised so as to bind principal. Means principal may save as is otherwise provided by last preceding section, that is section 202, revoke authority given to his agent any time before authority has been exercised so as to bind principal. 204, revocation where authority has been partly exercised. This is 204. Revocation where authority has been partly exercised. Principal cannot revoke authority given to his agent after authority has been partly exercised, so far as regards such acts and obligations as arise from acts already done in agency. 205, compensation for revocation by principal. 205. Compensation for revocation by principal or renunciation by agent. Renunciation by agent, where there is an express or implied contract that agency should be continued for any period of time. Principal must make compensation to that agent or agent to principal as case may be for any previous revocation or renunciation of agency without sufficient cause. Again, says that where there is an express or implied contract, that agency should be continued. Okay, now where there is an express or implied contract that agency should be continued for any period of time, principal must make compensation to agent or agent to principal as case may be for any previous revocation of remuneration of agency without sufficient cause. Says if says that where there is an express or implied contract that agency should be continued for any period of time, principal must make compensation to agent or agent to principal as case may be for any previous revocation or renunciation of agency without sufficient cause. 206, notice of revocation or renunciation. Okay, let me see what's going on there. It's 2 hours. That Facebook has not received no signals from video source for some time. Check that connectivity between the video source and Facebook is sufficient for source. It's April 27, 5:40 a.m., 5:32. Dated by versus signals. Why does Facebook has not received? I'm saying that this signals are receiving live video. Okay, what to do then? What to do? I cannot see this. It's saying noticing some signals. I think signals are receiving. Okay, what to do? Well, there's some message here on time. I'll continue, no problem. 2 hours, 7 minutes already left. So, okay. Say. So, notice of 2606, notice of revocation or renunciation. Reasonable notice must be given of such revocation or renunciation. Otherwise, damage thereby resulting to principal or agent, as case may be, must be made good to one by other. 207, revocation and renunciation may be expressed or implied. This is 207. Now, 207. Revocation and renunciation may be expressed or implied, or may be implied in conduct of principal or agent respectively. Now, it's 208, when termination of agent's authority takes effect as to agent and as to third person. It says 208. When termination of agent authority takes effect as to agent and as to third person, termination of authority of an agent does not, so far as regards agent, take effect before it becomes known to him, or so far as regards third person before it becomes known to them. This is 209. Agent's duty on termination of agent by principles death of insanity, or insanity, principles death or insanity. I'll read this now because these are similar type of. It says agent's duty on termination of agency. Agent's duty on termination of agency by principles death or insanity. When an agent is terminated. When an agency is terminated by principal dying or becoming of unsound mind, agent is bound to take on behalf of representatives of his late principal all reasonable steps, all reasonable steps Agent's duty on termination of agency by principal's death or insanity. When an agency is terminated by principal dying or becoming of unsound mind, agent is bound to take on behalf of the representative. Agent is bound to take on behalf of representatives of his late principal all reasonable steps for protecting and preserving of interests entrusted to him. This means all survivors, all legal heritages of agent or principal must be supported, must be taken care of by agent whose termination of agency by principal's death. Means when principal has died, automatically agency is terminated, but that agent has duty to moral duty to support the service. Then number 210, termination of subagent's authority. 210. This is termination of subagent's authority. This termination of subagent's authority. Termination of subagent's authority. Termination of surveillance authority. Termination of authority of an agent causes termination subject to rules herein contained regarding termination of an agent's authority of all sub-agents appointed by him. Agent's duty to principal. 211. Agent's duty to principal. This is 211. See. It's not coming in. What's the reason? Level. Now, it says is that I'll read from here. So, agent's duty to conducting principal's business. An agent is bound to conduct business of his principal according to directions given by principal, or in absence of any such directions, according to custom which prevails in doing business of same kind at place where agent conducts such business. When agent acts or otherwise, if any loss is sustained, he must make it good to his principal, and if any profit accuracy must, okay, if on any loss be sustained, he must take it good to his principal, and if any profit accrues, he must account for it. This is 211 agents. Let me say, in conducting principal's business, an agent is to conduct business of his principal according to directions given by principal, or in absence of any such direction, according to custom all prevails, which prevails in doing business out of business, says according to customs which prevails in doing business of same kind at place where agent conducts much business. Then we come to another one that you can say 212, skill and diligence required from agent. Okay, now we'll go there. 212. It says 212. This is 212. Skill and diligence required from agent. An agent is bound to conduct business of agency with as much skill as is generally possessed by persons engaged in similar business, unless principal has notice of his want of skill. Agent is always bound to act with reasonable diligence and to use such skill as as he possesses and to make compensation to his principal in response of direct consequences of his own neglect. Want, want of skills or misconduct, but not in respect of loss or damage which are indirectly or remotely caused, caused by such neglect, want of skill or misconduct. Then 200, 213 agents accounts. 213. Okay, let me move first. Agent's account. An agent is bound to render proper accounts to his principal. Agent is bound to render proper accounts to his principals on demand. 214. Agent's duty to communicate with principal. 214. Then agent's duty to communicate with principal. It's duty of an agent in cases of difficulty to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. Hmm. 215 principal right of principal where agent deals on his own. 215. Right of principal when agent deals on his own account in business of agency without principal's consent. If an agent deals on his own account in business of agency without first obtaining consent of his principal. Now, in business of agency, if an agent deals on his own account in business of an agency without first obtaining consent of his principal and acquainting him with all materials of circumstances which have come to his own knowledge on subject, the principal may repudiate transaction. And let me see what says. If an agent deals on his own account in business of agency without first obtaining consent of his principal and acquainting him with all materials. Alright. So if an agent deals on his own account in business of agency without first obtaining consent of his principal and acquainting him with all material circumstances which have come to his own knowledge on subject, principal may repudiate transaction if case shows either that any material fact okay any material fact has been dishonestly concealed from him by agent, or that dealings of agent have been disadvantageous to him. So now it's now 216, principal's right to benefit gains by agent dealing on his own account of business or agency. 216. Let me see, it's coming to 16 or not. 216. Is that 216, principal's right to benefit gained by agent. Principal's right to benefit gained by agent dealing on his own account in business or agency. If an agent without knowledge of his principal deals in business of agency on his own account. Here's that. Is that different? If an agent without knowledge of his principal deals in business of agency on his own account instead of on agent, it is an agent. I can't read it sometimes. It is an agent. If an agent without knowledge of his principal deals in business of agency on his own account instead of on account of principal is entitled to claim from the agent from the Right now, let me go further. 217. Let me repeat it again. If an agent dealing on his own account in business of agency without knowledge of his principal deals in business is if no okay. If an agent without knowledge of his principal deals in business of an agency on his own account instead of on account of his principal. Principal is entitled, right? Principal is entitled to claim from agent any benefit which may have resulted to him process. Now 217. 217. Agent. Agent's right. 217. Agent's right. I cannot see here with it. 17 agent's right. Alright, now 217 agent's right. We go there. 217 agent's right. Agent's right of retainer out of sums received on principal's account. An agent may retain out of sums received on account of principals in business of agency. All money is due to himself in respect of advance made or express property to buy any card. This means this is 217. Agent's rights. Alright, I can read here big file, small I. An agent may retain out of any sums received on account of principal in business of agency all money due to himself in respect of advances made or express properly incurred by him if conducting some business rehabilitation, you can say business, uh, you know, all money is due to himself in respect of advances made or expenses properly incurred by him in conducting such business, and also such remuneration as may be payable to him for acting as agent. So an agent may retain out of whatever sums received on account of himself, considering such 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 business, and also such remuneration as may be payable to him for acting in as agent. 218. Agent's duty to pay sum received for principal. An agent duty to pay sums received for principal subject to such deductions. Agent is bound to pay to his principal all sums received on his account. 218. 218. Agent's duty to pay sums received for principal subject to such deductions. Agent is bound to pay to his principal all sums received on his account. So, subject to such deductions, agent is bound to pay to his principals all sums received on his account. 219. When agent's remuneration becomes due. 219. When agent's remuneration becomes due. When agent's remuneration becomes due. In absence of any special contract, payment for performance of an act is not due to agent until completion of such act, but an agent may detain monies received by him on account of goods sold, although whole of whole of in absence of any special contract, payment for performance of any act is not due to agent until completion of such act, but an agent may detain money received by him on account of goods sold, although whole of goods consigned to him for sale may, may not have been sold, or although sale may not be actually complete. Once again, let's read. In absence of any special contract, payment for performance of any act is not due to agent until completion of such act, but an agent may detain monies received by all right, now we'll go to 290 is over, 220. 220. 220. This is 220. 220. Agent not entitled to remuneration for business. Okay. Agent not entitled to remuneration for business misconduct. An agent who is guilty of misconduct in business of agency is not entitled to any remuneration in respect of that part of business which he has misconducted. So, agent not entitled to remuneration for business misconducted. An agent who is guilty of misconduct in business of agency is not entitled to any remuneration in respect of that part of business which he has misconducted. After this is as also misconduct. Then 221 agents lying on principal's property. 221 agents lying on principal property. So it's 91 of 98 page. I think maybe in half an hour it's finished. Cannot say. Then says what's that? Yeah, it's here. Agents lying on principal property in absence of any contract to contrary. An agent is entitled to retain goods, papers, and other property, whether movable or immovable, of principal received by him, until amount due to himself and for commission, disbursement, and services in respect of same has been paid part. Alright, then paid part unless amount due to himself for, wait a minute, why it's not moving? Sometimes problem here is also, let me repeat it. In absence of any contract to contrary, an agent is entitled to retain goods, papers, and other property, whether movable or immovable, of principal received by him, until amount due to himself for commission, disbursements, and services in respect of same has been paid. Alright, now go to 222, that is agent to be indemnified against consequences of lawful acts. Agent to be indemnified. 222. Is section 222 of this act. And it says agent to be indemnified against consequences of lawful acts. Employer of an agent is bound to indemnify him against consequences of all lawful acts done by which says agent to be indemnified against the consequences of lawful acts. Employer of an agent is bound to indemnify indemnify agent against consequences of all lawful acts done by such agent in exercise of authority conferred upon him. So 222. Now go to 223. Agent to be identified against consequences consequences of acts done to is good faith. This is 223. Oh, 23. 223. Agent to be indemnified against consequences of acts done in good faith, where one person employs another to do an act, and an agent does that again. Act is God. Act in good faith. Employer is line up. Alright. Agent to be indemnified against consequences of acts done in good faith, where one person employs another to do an act, and agent does act in good faith. Employer is likely to indemnify let me do it again better. It says that font is a problem that where one person employs another to do an act, and agent does act in good faith, employer is liable to indemnify agent against consequences of that act through a though it cause injury to right of third person. Let me speak 223 from there itself. 222 there itself better continue. 223. Where one person employs another to do an act, and agent does act in good faith, employer is liable to indemnify agent against consequences of that act, though it causes an injury to rights of third person. Now come on to 224. Non-liability of employer of agent to do a criminal act. 224. Non-liability of employer of agent to do a criminal act. Where one person employs another to do an act which is criminal. Where one person employs another to do an act which is criminal. Employer is not liable to agent either upon an express or an implied promise to indemnify him against consequences of that act. 225. Compensation to agent for injury caused by principal's error. 225. Compensation to agent for injury caused by principal's neglect. Principal must make compensation to his agent in respect of injury caused to such agent by principal neglect or want of skill. Now 226 enforcement and consequences of agents' contracts. 226 enforcement and consequences of agents or contracts. Contracts entered into through an agent. Contracts entered into through an agent and obligations arising from acts done by an agent. Two 26 then, contracts entered through an agent and obligations arising from acts done by an agent may be enforced in same manner and will have then 226 that is 226, let's go to 226. It's going to end soon, I think few more. 226 very boring anyway, what to do, no other way, you have to learn it because this is a safe cover for future. Two 26 contracts entered into through an agent and obligations arising from acts done by an agent may be enforced in same manner and will have same legal consequences as if contracts had been entered into and acts done by principal in person. Again, contracts entered into through an agent and obligations arising from acts done by agent may be enforced in same manner and shall have same legal consequences as if contracts had been entered into and acts done by principal in person. Yeah. After that, principal how far bound when agent exceeds authority. Principal 227 227, okay. I do not see the lot, let me see. It's not seeing, is it? 227. That's there. Principal how far bound when agent exceeds authority. When an agent does more than he is authorized to do, and when part of what he does, which is within his authority, can be separated from part which is beyond his authority, so much only solve to solve. So much so many small fonts. 227, difficult for me to read like that, 227, I can't read here, I'll read here only. Let me first. When an agent does more than he is authorized to do, and when part of what he does, which is within his authority, can be separated from part which is beyond his authority, so much only of what he does as is within his authority is binding between him and his principal. 228. Principal and bound. Principal not bound with when access of agent's authority is not separable. Principal not bound. 228. Well, only I think few more articles and sections in this. Let us see how many more. Principal not bound when access of agent's authority. This was this section. It says 228. Principal not bound when access of agent's authority is not separable. Where an agent does more than he is authorized to do, and what he does beyond the scope of his authority cannot be separated from what is within it, principal is not bound to recognize that transaction. 229. Consequences of notice given to agent. Consequences given to notice, this 29 to 29. So consequences of notice. फिर again consequences of notice. Consequences of notice given to agent. Any notice given to or information obtained by agent, provides it be given or obtained in course of business transacted by him for principals shall, as between principal and third parties, have same legal consequences as if it had been given to or obtained by principal. 230. Agent cannot personally enforce nor be bound by contracts or behalf of principal. Agent cannot personally enforce nor be bound by contracts on behalf of principal. This is 230. say says that says agent cannot personally enforce nor be bound by contracts on behalf of principal. In absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of principal, nor is he personally bound by them. Presumption of contract to contrary, such a contract shall be presumed to exist in following cases. Now, which are that? Number one, where contract is made and where contract is made by an agent for sales or purchase of goods for a merchant resident abroad, where agent does not disclose name of his principal, where principal though disclosed cannot be sued, and 231. So there are three conditions, and this is in this presumption of contract to contrary, such a contract shall be presumed to exist in following cases. Shall that where you can say in absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him where contract is made by an agent for sales or purchase of goods for a merchant resident abroad, where agent does not disclose name of his principal, where principal though disclosed cannot be shown. So made by him not disclosed. 231. It's not clear here, I think. 231. But it says 231. It says right of parties to contract. Says that right of parties to a contract made by agent not disclosed. It is if an agent makes a contract with a person with neither who neither knows nor has reason to suspect that he is an agent, his principal may require performance of contract, but other contracting party has as against principal same rights as he would have had as against agent if agent had been principal. If principal discloses himself, if principal discloses himself before contract is completed, other contracting party may refuse to fulfill contract. If he can show that if he had known who was principal in contract, or if he had not known that agent was not a principal, he would not have entered into a contract. Performance of contract. Performance contract with agent suppose alright. 232, let us see. Well, I should quickly keep off. Oh, no, I should go as usual. Don't kick off. 232. Better, let us complete this sequence. Performance of contract with agent, let's say was 232. This is very patient job. People should understand what we are talking. That's important. So it's saying 232 and 232. Performance of contract with agent supposed to be principal, where one man makes a contract with another, neither knowing nor having reasonable ground to suspect that other is an agent principal if he requires performance of contract can only obtain such performance subject to rights of and okay 232. Where one man makes a contract with another, neither knowing nor having reasonable ground to suspect that other is an agent principal if he requires performance of contract, can only obtain such performance subject to rights and obligations subsisting between agent and other party to contract. 233. Right of person dealing with agent personally liable. Right, this is 233. Right of a personal liable, 233. In cases where agent is personally liable, a person dealing with him may hold either him or his principal or both of them liable. Simple. Consequence of you can say liable. Alright, 2001 liable. 234. Consequences of including agent or principal to act. Let us say this is 234. 234. It is consequence of inducing agent. Let us see here. It's not clear. It's not clear. Consequences of inducing agent or principal to act on belief that principal or agent will be held responsible, exclusively liable when a person alright, let me say 2 from 34. April 24. Consequences of inducing agent or principal to act on belief that principal or agent will be held exclusively liable when a person who has made a contract with an agent induces agent to act upon belief that principal on a belief when a person who has made a contract with an agent induces the agent When in this, when an agent induces agent to act upon belief that principal will only be held liable, or induces principal to act upon belief that agent only will be liable, he cannot afterwards hold liable agent or principal respectively. This is radical. Consequences of inducing agent or principal to act on belief that principal or agent will be held exclusively liable when a person who has made a contract with an agent induces agent to act upon belief that principal only will be held liable, or induces principal to act upon belief that agent only will be liable, cannot afterwards hold liable and liable agent or principal respectively. Liability of pretended agents. This is 235. Liability of pretended agents. 235. Near us with 235. Let's see the IRS with 235. 235. Liability of pretend a person untruly representing himself to be authorized agent of another, and thereby inducing a third person to deal with him as such agent, is liable. Alright, now I think it's the ending one. I'm also feeling very much depressed on this act because this is too old act, 1873, 1887, 1859. A person untruly representing himself to be authorized agent of another, and thereby inducing a third person to deal with him as such agent, is liable if his alleged employer does not ratify his acts to make compensation to other in respect of any loss or damage which he has incurred or by so telling. Or it's a liability of pretended agent. It's a person untruly representing himself to be authorized agent of another, and thereby inducing a third person to deal with him as such agent, as liable if his alleged employer does not ratify his action to make compensation to other in respect of any loss or damage which he has incurred by so dealing. And 236, that is, person falsely contracting as agent or not entirely. Okay, 236, this says falsely representing, falsely contracting as agent not entitled to perform. A person with whom a contract has been entered into in character of agent is not entitled to require performance of it if he was a realty acting. If he was a realty acting not as agent but upon on his own act. And that is 236. Go to 237. Liability of principal inducing belief that agents unauthorized act were authorized. 237. Yeah, I'm sure that possibly. Let us see here. Let us see here. So now this is 237. Liability of principal. This is liability of principal individual indulging belief the agent's unauthorized act were authorized. When an agent has, without authority, done acts of, done acts or incurred obligations to third person. Alright, 237 is over. Now we'll go to, let me see 2000 again better. When an agent has, without authority, done acts of incurred obligation to third person on behalf of his principal is bound by such acts or obligations if he has, by his own words or conduct, induced such third persons to believe that such acts and obligations were within scope of agent's authority. 238, and that is effect on agreement of misrepresentation of part fraud by agent. This is 238. What it says that effects of on agreement of misrepresentation of fraud by agents. Misrepresentation made of frauds committed. Misrepresentation made of frauds committed by agents acting in course of their business for their principals have same effect on agreements made by such agents as if such misrepresentations on frauds had been made or committed by principals, but misrepresentations made on frauds committed by agents in matters which do not fall within their authority do not affect their principal. This is 238. So what 238 says, let us see once again. It said that 238. 238 says 238. So we are at end of this contract, this act. Now misrepresentation and fraud it is, and then I think so. Now what I say that in fact this is 238. There are 238 clauses or sections in Indian Contract Act. This we so far actually got to understand. If you see Indian Contract Act is very old but very comprehensive document which you may not be knowing, all of you, but we have gone through this very boringly because it's like that. This Indian Contract Act 1872 Act number 9 of 1872. This was, enacted during British regime, and its title was maybe called Indian Contract Act. अब मैं थोड़ा आपको हिंदी में बता देता हूँ। एक्चुअली इंग्लिश थोड़ा ऐसी होती है। आप जो भी कॉन्ट्रैक्ट करते हैं, कोई भी कॉन्ट्रैक्ट करते हैं, पहले समझना होगा कॉन्ट्रैक्ट होता क्या है। इसी बात को समझने के लिए मैं ये आपको पढ़ के बता रहा था। कॉन्ट्रैक्ट या करार कह दीजिए आप कोई भी करार करते हैं, आपको पता भी नहीं होता कि आपने करार किया और वो करार हो जाता है। इसका मतलब ये नहीं कि लिखित में हो, कोई ज़रूरी नहीं है। एग्रीमेंट होता है, वो कानून के हिसाब से, नियम के हिसाब से लागू होना चाहिए, उस पर एक्शन होना चाहिए, वो ज़रूरी होता है। अगर वो कानून के हिसाब से नहीं है तो वो एग्रीमेंट नहीं माना जाता, बेकार, काम इलीगल है। आप कभी कहीं जाते हैं घूमने, टिकट लेते हैं हवाई जहाज़ का, ट्रेन का, कुछ भी, कोई सामान खरीदते हैं, कोई सर्विस लेते हैं, पैसा देते हैं और काम लेते हैं, वो सब करार है, चाहे वो कितने का भी हो। उस पर डॉक्यूमेंट हो कि ना हो कोई बात नहीं है। सर्विस ली, सामान लिया, कुछ लिया, पर्ची ली, रसीद ली, तो सब कहीं ना कहीं कॉन्ट्रैक्ट है। लेकिन कॉन्ट्रैक्ट असली वो होते हैं जहाँ आपको ज़रूरत पड़े तो कोर्ट में जाना पड़ता है, वो एडमिट हो वहाँ पे। अब मेन बात तो है, कॉन्ट्रैक्ट में होते हैं पार्टी, एक वो होता है जो पैसा देता है, एक वो होता है पैसा लेता है काम कराने का। पार्टी एक होती है, पार्टी दूसरी होती है, और दोनों की बराबर रिस्पॉन्सिबिलिटी है, क्योंकि वो कॉन्ट्रैक्ट है। इस बात को समझाने के लिए मैंने ये सब कहा। कॉन्ट्रैक्ट दो आदमी ज़रूरी है, उसमें एक आदमी का कॉन्ट्रैक्ट नहीं होता है। और कॉन्ट्रैक्ट का मतलब जिम्मेदारी होता है, खेल नहीं होता बच्चों का। और शायद लोगों को पता भी नहीं है कि हमारे देश में कोई कॉन्ट्रैक्ट का कानून भी है, नियम भी है। उसको समझाने के लिए मैंने आपको ये कॉन्ट्रैक्ट का जो नियम है, अधिनियम है, पढ़ के सुनाया। बहुत सारी इंग्लिश होती है, सबको नहीं समझ आती है, क्योंकि अंग्रेज़ों की भाषा है लिखी हुई, चेंज तो हुई नहीं, लेकिन समझनी तो पड़ेगी। और मैं समझता हूँ समझने में कोई इतनी दिक्कत नहीं आनी चाहिए। मेन चीज़ यही थी कि हम आखिर समझते क्या है। जिस तरह आप लोग भारत का संविधान नहीं समझते, उस तरह ये भी नहीं समझते। दुख इस बात का होता है। या मैं कोई ऐसी बात कहने को नहीं बैठा कि आप समझते नहीं समझते, लेकिन आपकी जिम्मेदारी है। आप अपना मकान बनाना चाहते हैं, किसी को ठेका देते हैं, कॉन्ट्रैक्ट करते हैं, आपको पता भी नहीं होता उसमें क्या लिखा गया, लेकिन आप कॉन्ट्रैक्ट कर देते हैं। चाहे आप पूरा पैसा देने वाला हो, मटेरियल वाला, मकान बनाने वाले को ठेका दें या लेबर को दें, आपको कहीं ना कहीं साइन करना पड़ता है। कोई भी चीज़ हो, करना पड़ता है। वो कॉन्ट्रैक्ट में आदमी फंस जाता है जब तक कि उसको पूरी नॉलेज ना हो। और उसी को समझाने के लिए मैंने ये स्टार्ट किया कॉन्ट्रैक्ट के बारे में आपको बताना। ये सब जगह आपकी लाइफ में आएगा। इट शैल अप्लाई टू यू ऑन ऑल एक्टिविटीज़ इन योर लाइफ। इंश्योरेंस है, बस का किराया है आप ले रहे हैं, ट्रेन है, कोई और चीज़ है, और कोई ऐसी सेवा आप ले रहे हैं, वहाँ भी सब कॉन्ट्रैक्ट होता है। और हर रोज़ आप कॉन्ट्रैक्ट करते हैं, लेकिन समझते नहीं हैं। कोई बात नहीं है, एक दो दिन के कॉन्ट्रैक्ट से कुछ फ़र्क नहीं पड़ता है, लेकिन जो लंबे समय के लिए होते हैं उसका तो समझना बहुत ज़रूरी है। इसलिए मैंने समझाया, एक पार्टी दूसरी पार्टी दोनों साइन कर रहे हैं, कोई गवाह सामने है, कॉन्ट्रैक्ट है। लेकिन कॉन्ट्रैक्ट में जो भी होता है ऐसा होना चाहिए जो गलत ना हो, जो पब्लिक पॉलिसी के खिलाफ ना हो, उसके विरुद्ध ना हो, जो हमारा संविधान कहता है उसके हिसाब से हो। उसमें ऐसी कोई चीज़ ना हो जो गलत हो। आप कॉन्ट्रैक्ट कर लीजिए, मैं आपको इतने पैसे दूँगा, जाकर उसको मार दीजिए, वो कॉन्ट्रैक्ट नहीं है, पब्लिक पॉलिसी के खिलाफ है। आप अपनी पॉलिसी जो सही है देश की या दुनिया में कहीं भी है, उसके हिसाब से करेंगे तो कोई प्रॉब्लम नहीं आएगा। कॉन्ट्रैक्ट तो करना पड़ेगा, कॉन्ट्रैक्ट से बच भी नहीं सकते। बेशक चाहे लिख के ना करें, बोल के करें, ठेका कह लीजिए, कॉन्ट्रैक्ट कह लीजिए, करार कह लीजिए, कुछ भी कह लीजिए, दूसरा ये कि आप जब कोई काम कराते हैं तो हम आपको इतना पैसा देंगे, उसमें लिखा जाता है, वो भी ज़रूरी है। उसको कंसिडरेशन कहते हैं इंग्लिश में। आप मेरा ये काम करेंगे, मैं इसके बदले में आपको इतना पैसा दूंगा, वो कंसिडरेशन कहलाता है, वो समझना ज़रूरी है। एक पार्टी होती है जो कहती है भाई पैसा देने वाली आमतौर जो पार्टी होती है वो पार्टी एक होती है, पार्टी वन होती है, और जो पैसा लेती है पार्टी टू होती है। जो पार्टी देने वाली, पैसा देने वाली होती है उसे एम्प्लॉयर कहते हैं, और दूसरे को एक तरह से एम्प्लॉई कह सकते हैं आप, या उसको है दोनों जिम्मेदार उस काम के लिए। कॉन्ट्रैक्ट है, एग्रीमेंट है, दोनों ने साइन किए हैं तो दोनों बराबरी का हक रखते हैं। अब उसको ठेकेदार कह लो, कुछ भी कह लो, मेरे हिसाब से दोनों बराबर हैं। एक ने एम्प्लॉय किया है, एक एम्प्लॉयड है, तो किसी भी पीरियड के लिए है, किसी भी समय के लिए है, दोनों उस पर अपनी जिम्मेदारी निभा रहे हैं। काम करने वाले ने काम करना है, पैसा देने वाले ने पैसा देना है। सिंपल सी बात है। उसकी ड्यूटी पैसा देने की है, पैसा अरेंज करने की है, और उसकी ड्यूटी काम करने के समय पे क्वालिटी के हिसाब से काम करके देना है। ये चीज़ इसमें खास तौर से है जो बहुत आवश्यक है समय में। इसलिए मैंने थोड़ा आपको अपनी हिंदी में बताना चाहा। गुमराह होने की ज़रूरत नहीं है। आप कांटेक्ट करके किसी को अथॉरिटी दे सकते हैं, या आप मेरा अटॉर्नी है, इस कॉन्ट्रैक्ट को संभालिए, उसको आप एजेंट कह देते हैं। इसमें एजेंट भी कहा गया है, और जो चीज़ अधिनियम में होती है वो वही होती है। एजेंट लिखा है तो एजेंट है, वो आपके अधिनियम के हिसाब से है। और आप अगर कॉन्ट्रैक्ट साइन कर रहे हैं तो वो भी अधिनियम के हिसाब से है। आप पार्टी एक हैं या कोई पार्टी दो है, पार्टी एक भी है, दो भी है, और भी हो सकते हैं। कॉन्ट्रैक्ट का मतलब ये था, इसलिए मैंने आपको ब्रीफ में समझाया आपकी लैंग्वेज में कि थोड़ा समझना ज़रूरी है। वो लंबा होता है, सब इतने सारे क्लॉज हैं उसके अंदर होते हैं, सब में होते हैं, ये सब सेक्शन होते हैं, कोई नई बात नहीं है। कल को अगर आप इसके हिसाब से कॉन्ट्रैक्ट नहीं करेंगे, जो बातें भी हैं वो कॉन्ट्रैक्ट माना ही नहीं जाएगा। ये नहीं कि सीक्वेंस में हो, ये चीज़ें होनी चाहिए। आप पार्टी वन लिखेंगे, एम्प्लॉयर माना जाएगा, पार्टी दो लिखेंगे, एम्प्लॉय माना जाएगा। एम्प्लॉय का मतलब नौकरी से नहीं है, उस काम से है। उसको कुछ लोग कॉन्ट्रैक्टर भी लिख देते हैं पार्टी टू को, और पार्टी वन को एम्प्लॉयर लिख देते हैं। वो मतलब है कहने का, वो अपने हिसाब से होता है, लेकिन दोनों ही इक्विटी पे, दोनों जिम्मेदार हैं। कोई छोटा नहीं है, कोई बड़ा नहीं है, ये बात समझनी चाहिए। कॉन्ट्रैक्ट एक्ट है ये, सारे कॉन्ट्रैक्ट इसी को फॉलो करके होते हैं, इसकी वायलेशन में नहीं होती। आप अपने हिसाब से कॉन्ट्रैक्ट कीजिए, लैंग्वेज अपनी यूज़ कीजिए, कोई दिक्कत नहीं है, कर सकते हैं। नाउ दिस वाज माय एक्चुअल ड्यूटी टू एक्सप्लेन टू यू about contract, because I will now go on further for such talks later on in future. And somebody also asked me about contract management, because when you manage something you do some contract. As I so far explained to you about project management, quality management, safety management, other managements, all these managements are actually contract based. And where you go, whatever you work, somewhere some contract exists. If you get some job, some contract is there, employment contract. If you get some tender, it's contract, work contract, service contract. So insurance contract they say, and same thing, health insurance contract, medical claim, after all that's also a contract, medical claims. So everywhere in your life you will meet such contracts. Just like service contract for electric bills, service contract for water bills, they are giving you service, electrical supply, and they're charging you, are paying them. It's also a contract. Contract is contract. When two persons move on same track, it's called contract. CONTRACT. Contract, both are moving on same track, not going this way and that way, then they will derail. When going parallel on the same track, it's train and which both are sitting and train is moving. That point we have to understand. And contract will describe its own responsibilities later on. We will see that one. My purpose of a contract explanation is that, and in there are so many other issues which are very important one, which will come later. For example, agent is shown there. It's very important. Agent and principal relation it is established. One is principal and one is agent. A person who is appointing an agent is principal, and an agent is working for someone as principal. Principal and agent relation. This relation is on contract. You cannot say, oh, this is my agent. You are simply saying, this agent for what? Who appointed that agent? That's the point. There should be some principle for that. Just like you say, oh, this person is property agent. What is agent? That agent is working for whom? That is freelancing agent. But once that brings a proposal to you, this house you can buy, in that case, that agent becomes servant to that principal. That agent proposes that property because that property owner has authorized this agent verbally or otherwise that take care of my property. I want to sell it or I want to buy some property. So though it may not be in writing, but relation is established with a property agent. That agent is dealing with the many principals. He may be dealing with 20 properties. So that agent is all property. Though it's not written, but it is established or it's verbal. So there is a relation. Agent, and just like it was for bailor and bailey, pawn or pawnee. It's like that, means so many relations are established there. This is all because of contract. And these relations should be clear. Contract, who can do contract? It clearly says a person who is major in age only is entitled to enter into contract. And that is 21 years. Majority is 21 years. You must be above that. Number one, you must be having sound mind. Number two, if you are not having sound mind, or you are having flexible mind, sometimes you are sound mind, sometimes you are unsound mind. When you are having sound mind, at that time when you enter a contract, that's only valid. If you are in unsound mind and enter in contract during that duration, this contract is invalid. So one should have sound mind, one should have clear understanding of contract language. So age is a factor, mental status is a factor, clear understanding of contract is a factor, free will is a factor. Free will, no under pressure will. You say, no, you do it as I say, you agree. If I am party one, I said, no, you agree with this, and I am powerful. I force that person signs. That is under force, that contract is. That's not under free will. That point we have to understand. The existence and establishment of free will is extremely important. Free will based contract is valid, under force contract is not valid. I put a gun on you, sign this. No, that's not valid. That's not valid. So there are certain conditions: age factor, mental state factor, free will factor, consideration factor. There must be a consideration. Consideration means what result it will give to other party. I say you make house for me, that party make house. I'll pay you this much, that's the agreement. This much for each item or total item. That party shall get this much, and I say you, this is time for you. You have to finish in this time. And that's also a condition there. I have given time. And if you do not do in this time, you have to face this action. That must be clear. Because time is limit. I cannot say whenever you do it. No. Contract has a time limit. Contract cannot be open forever. It has to close one day because it started one day. All these conditions are covered under Contract Act. We have to understand Contract Act first. Yes, it is very boring, I know. You are very bored by me. But this is book. If you do not go like this, you cannot understand this and somebody will trap you. If you understand what you are doing, there is no need of court. Court is required because you do not know something. I don't want my agreement, my dispute resolution by certain lawyer or a judge. I don't need them. I need my contract clear. I know what I have to do. Why should I involve them for and pay them for this? And I understand that because I don't understand, then I need services of court. Both parties have some misunderstanding, they don't agree on something. I have to pay ultimately. I am number one, I am employer, I have agreed, I'll pay you this much. And then there are some disputes, so we have to go to arbitration or court. Why? I have to pay. It's not a joke. If he has worked for me, I have to pay. Even if I don't pay, court will force me to pay. So why to go to first waste time for both of us? Better clearly understand this with maturity. You are mature means you are adult. You are, mature in age. You are having good mind here, sound mind. You can think. You have a will to get that work done. You have a will to know what you are signing. There's no force on your head. No, sign it. No, it's not necessary. That's not a contract. Free will. And you should know. And also, that person has a right who is party to, because he will take payment from you for work. He must be sure that you have that financial capacity, which is a natural right. You have to tell him, I have funding for this. You won't be having any problem. You may have funding from through bank loan or somewhere else, because if you don't have any money, there is no meaning that that person should waste time for you. And you have no right if you don't have funding. If you are not having that potential, no financial capacity, and you say, I want to make my house, it's not sensible. You cannot do that. This is another kind of fraud. Another kind of fraud. You cannot force, you cannot engage someone if you don't have money, if you don't have budget. That's also practicality. That's what it says fraud should not be based on fraud. I am forcing you to this contract because I know you and you know me, you know my capacity, I never cheat, and you trust that me, means that's a breach of trust. Contract is very complicated document which leads to life of someone making one or breaking one. Contracts are not that easy. These are of course equity based but also potential based. Both parties should know each other very well. Very well means not personally but potentially. The capacity of each must be known. If I am going to do work of many crores for you, I should know that you have that capacity. You can pay me back. You can give me advance. I can work for you because I have to depend on your capacity and your trustworthy nature and your, working nature, professionalism in your nature. Only then I submit to you. Otherwise, why should I submit to you? My question is, submission doesn't mean something else. It means submission on contract. Contract is submission by both these parties. This is not slavery. This is not big or small. Contract means we are moving on the same track. So simple. We agreed on some conditions. We have some scope. We have some objective. We have some goal. To achieve that, we move on some contract which is agreed by both parties together. So where is big or small? Where is superior or inferior? This is our mental state only. We have one goal. The scope of work is mentioned in contract. This is the scope of work. This is for both. One has to pay for this, other has to do it. So simple. Where is difference? You are not doing any obligation on me by paying me. I am not doing any obligation specifically for you because I am doing this for you. I am paid for that. I am given remuneration for that. What I am doing, it's my problem if my price is wrong. It's my problem. I fail to calculate it correctly. That's my problem. So I have to be competent enough to understand contract, understand liability, understand time limit, understand am I able to do that? Do I have capacity in me to do that? I have to evaluate first, and based on my offer or based on my tender or bid or my details to other party one, that party must have a right, that party has a right to make sure what I have given or submitted, it indicates that I am capable to do that. All that must be clearly understood. There should be no lacuna in that. That's very important point. It should be clearly understood in black and white without any doubt, because it is contract. It's not one day job. Yes, I say you travel, that's a contract of course, but those are limited level contracts. When you say, oh, I take a flight ticket, I go to USA or to some other city, it will journey of 2 days. That contract finishes. Once you take off that flight and once you land and comes out of flight, plane, that is over. That contract terminates. Discharged. Similarly, when you complete your journey by train, that contract discharged. Similarly, bus journey or whatever, those are of course contracts, but not of that magnitude as I am talking of. And I am particularly of major contract concern here, which amounts into crores. You are going to do a housing work, you are going to do some building work, you are going to do something else where crores and crores and crores are invested by some people for this real estate business or some other business, or multinational business companies are doing oil facilities orders. For that there are so many complications and such projects move on for years. Oil facility moves for many years. Similarly, your construction houses scheme, which will take 2 or 3 years to move from commencement to completion. That point we should understand, we must understand that point. There actually contract touches. That contract is real in a sense. You have to stay on that contract for years together, and there is a definition of time limit. You have to finish in that. There is a definition of quality, there is a definition of quantity, there is a definition of human power. There is so many definitions which are all called specifications, contract forms, technical management drawings, and rules and regulations and codes and so much so forth. All those documents are binding you. All those specifications bind you. All the designs bind you. All timing limits bind you. All your financial terms bind you. Everything, every mentioning page binds you. Binds you. Cannot run away from that because you have signed that document. Page by page, every page you have to sign. You have signed contract form. You have signed every form. That is your binding between two. You are not bound alone. That party one is also bound. So you are binding with two. Party one and party two. You cannot pull away from each other until you are on that contract, and once you discharge, it is finished. When you come in contact, this contract signed and commissioning starts. Work is ongoing, and it's finished. Contract is over. But that contract travel, that contract journey, where we perform both, not one, is very rough terrain because work is done, not speech. Results are achieved, not talks. That terrain is very rough as far as performance is concerned, but once completed, that becomes a palace, that becomes a road, that becomes a power station, that becomes an oil plant. Any, whatever you think, it can become. So just think, for that result, for that final milestone, for this total result, how much you have to do, how many people shall be involved, where from funding comes, everything involves, how many people are involved, bank is involved, party is involved, resources are involved, government is involved, authorities are involved, your people involved, and so many. So only because of this contract. If this contract does not exist, everybody goes away. And this contract is then also later on would bring is also that competent to pull more contracts from other parties who are subordinate to this contracting party. So that's why I thought a lot on this. Why don't we think a lot? Why should I be subservient to someone else? I have to think. Let us have a basic thinking of this. Why we organize like this? This means this involves obligation, this involves liability, this involves responsibility, this involves performance, this involves life and soul, this involves management, this involves not left any part of society, this involves everything. This is complete box. This is complete box. It's having so many items in this on which rolls this contract. So this contract is not simply a document. On this contract depends jobs of many, human resources and machines and bank and all. This contract can result in hundreds of disputes. This contract can result in suspension of project. This agreement can result in so much court work and arbitration work. This can result in any havoc. This can result in death due to accidents. So we have to be very careful. And if we just a little bored to understand what contract is, it shall result in benefit to everybody. That is where I stand on this to understand this. And I would suggest all engineers, particularly civil engineers and mechanical engineers, to be careful. Don't think that you are engineer alone. Don't think that you're only an engineer. No. You are a contract man. You are an advocate unto yourself. You are a judge unto yourself. You not only to judge only engineering decisions, you have to judge contractual decisions. You have to make decisions. Think it completely differently. You are a multi-professional in one body. Don't keep in your mind, I'm engineer only. No. Once you are a professional, you must have knowledge of all those subjects which involve on your job. That is called interactive disciplinary management or interdisciplinary management. You are not only a discipline engineer, you are many discipline engineers. You have to deal with electrical guy, you have to deal with HVAC guy, lift guy, elevator guy, services guy, many more guys, many more engineers, and you have to interact with them on site as well as in office, as well as on contract. You have to devise subcontracts based on your contract. You have to devise many more documents based on your documents. And based on this, you have to then communicate with them regularly without any fail. You may communicate by post or by mail. I'm not talking of that. But that is your job. Ordination, subordination, ordination, abscissa, abscissa, everywhere, x-axis, y-axis, z-axis, this axis. You are everywhere. Think like that. There's nothing wrong in this. Professional is professional. Your job is to deliver, and you cannot deliver singly. No, take RCC, don't worry about practical. Take RCC, don't worry about HVAC. No, cannot. Take RCC, I don't worry about false ceiling. No, it doesn't work. Change your mindset. Be common professional with top of engineering. Top with engineering, but be common professional. Think at time as lawyer. Think at time as judge. Think at time as contractor. Think as time as owner. Think at time as worker. Think at time as anybody, whosoever. When you start doing that, your brain shall automatically work in that direction. Stop your degree at your university. After that, forget degree and learn. Simple. Bending movement is okay in theory of structure, but in field, bending movement doesn't work. Deflection doesn't work. That is drawing. It will give you answer. Or you can work also, no problem. But that doesn't give you final answer. You have to work on engineering coordination. You have to work on engineering management. You have to work on contracting management. You have to work on safety management. You have to work on quality management. You have to work on planning management. And on top of that, you have to work on general management. General management, which nobody can teach you. If somebody says university can teach, then university itself doesn't know what is general management. General means general, handle everybody. If you can do that, you are best person. But there is still question mark on that because of our missing mindset, partly missing mindset. I would not say fully missing mindset. A partly missing mindset, maybe 25% mindset is not that. We have mindset, but 25% of our mindset does not accept this requirement, where we fail. If you make that 25% mindset, your mind will be 400%, I'm sure. Because then you use this mind to expand this, and expand this. Don't rely on others. Documents are the rely on documents. Document is solution. Remember, document is an exclusive solution all over world. You can't move without that. Documents is your teacher. It was document of books that you study in your university. These were documents. Your professors used those documents to teach you. And if you don't document your lesson, nobody can learn from you. So document. All these laws are documents. Our constitution is documents. Our contracts are documents. Our specifications are documents. This video I am making is a document. Everything is document. And if you make yourself document oriented, you shall yourself become a document. Means a resource person. You shall become a resource person, so that people can refer their problems to you to get their solutions. That is major point you can find. That is more important you can find. But you have to think that, you have to decide that. It's not that easy as I am speaking. I am speaking because I experienced all that. That you have to move yourself. You have to be proactive. Nobody will help you if you don't help yourself. Yes, if you move proactively, you move sometime, try, people shall follow you. This is nature. You move little, one time, two times. They won't hesitate. They will say, oh, let me. But if they see you are really moving, they shall automatically move to you. It happens because everybody finds some leader. Why is that leader? Unknown person. It's not seen. But when you work, they, oh, this man can lead. Okay, I ask him. It takes time, some time. If you have confidence, you are a leader everywhere. Don't shy. Be confident. You are leader. You can be wrong. Doesn't matter. Error can be checked, but not capacity. Remember. Sometimes you are wrong. You have a chance. You have an opportunity to amend yourself, modify, but movement should not stop. You should not sit, somebody would come and help me. No, sorry, nobody would come. When you are engineer, people expect something of you, not to give to you something. Everybody expects you to work as an engineer. And engineer means real engineer. Real engineer who can move, and who can move. So you can say contract engineering, I can say it's contract engineer. We say in field contract engineer, design engineer, billing engineer. People call it valuation engineer, value engineer. Why? So contract is our engineering, which means contract engineering means we are part lawyer, part advocate, because you have to refer to laws. Construction itself involves many laws. It involves Contract Act, it involves Arbitration Act, it involves Labor Relation Acts, it involves many more acts. Many more acts. You have to learn them. You have to learn hundreds of codes. That is what I say. It's very important to try to mold yourself into that environment if you really want to work as leader on projects. I have seen people, they don't confine themselves to their profession. They move everywhere and they are successful because thinking and thinking is required. Do not bind your mind with civil engineering, mechanical engineering. No, open it. I can understand that's the reason that it teach us. When I learned mechanical engineering in my diploma and degree, when I understood studied electrical engineering, it was not because I would be electrical engineer or a mechanical engineer. It was because it's required for purpose coordination. I fully qualified electrical subject. I fully qualified mechanical applied thermodynamics subject. I had to qualify. There's no other way. This is part of syllabus. So it doesn't mean that I'm a mechanical engineer. It doesn't mean I'm an electrical engineer. But coordination is required. I should know what is voltage and what is ampere. I should know what is cable. I should know what is machine. I should know what's duct. All this we should know. And that's where we stand. It's very important. Don't isolate yourself in a profession. Involve everywhere. Inclusive you are, not exclusive. I am inclusive engineer. I associate everybody and everyone associate me. That is required. With this, thank you very much. I'll now start tomorrow about Institutions of Engineers India Charter talk, which is very important for me at present moment. And then after that we shall take up FIDIC as a contract, which is called, and that's very important. So with this, I thank you all for things indeed. I can see. So